Hi everyone. After my first video on Christmas Day, I promised you that I would have a video ready by the first New Year's Day. I'm sorry I lied. Guys, I have been giving the second video a lot of thought. And today we are going to talk about triangulation and what is the steps you need to take to break triangulation and to fight back against it. I'm going to start off today by discussing the Domestic Violence Act. The Domestic Violence Act is the worst possible thing that could happen to a father. The intention of the act had nothing wrong with it, and the people that wrote the act, I am certain, did not have as its intention to remove every single parental right you have under the Children's Act and under the Constitution. Now let me explain to you why. You can get a protection order on a mere allegation. Now remember, referring back to triangulation, that's where it starts, with false allegations. The bar of probability is very low in acquiring a protection order. That means a false allegation can be made, and within 40 minutes, a protection order is issued against you, whether the allegations are true or not. Now, in common law, which have been around for ages and which also protects our constitutional rights, if somebody accuses you of anything wrong under the Protection Act, or an incident that would now fall under the Protection Act, they would have gone to a police station, laid a charge against you for abuse. The charge would then have been investigated. The investigating officer would have made a recommendation to the National Prosecuting Authority, and depending on what they decide, only then would a charge be laid against you and you would be called to a court of law to face your accusers in a court of law. Now that's gone. First of all, what happens is, because the protection order is issued within 40 minutes, your children now think that all the other adults in the world agree with their mother that they have been abused, or that she has been abused. So immediately, your credibility as a father has been tarnished forever, which no court in this country, which no magistrate or judge can give back to you. That's number one. I'm going to play you a small clip, which is a clip that I put together. It's an infographic of a real incident. Now, there's no names, nothing is mentioned, and it's about a farmer or a farm owner that have actually gone through this. Morning of 6 December 2016, the father was awoken by his staff on the farm and informed that the removals truck, high-tech security, the sheriff and the police was on his farm to deliver a protection order and a divorce summons. He was informed that his children was no longer on the farm and that they had been removed without his permission during the night by the mother's mother and her caretaker. The police explained the protection order and its content to the father, but what stood out in the protection order granted was that all the furniture was to be given to the mother and that the father had to pay 30,000 Rand relocation costs as well. The father declined the furniture removal order and asked the police to provide a warrant of execution. The father would not budge on the furniture, although he subsequently paid the relocation costs. The divorce summons received that morning included allegations that VTTV Pty Limited and the Nganduzi Trust was indeed the father's alter ego, and very substantive evidence was attached to the summons to prove it. The intention was to place a great deal of pressure on the father and shock him enough to settle financially immediately. The protection order was designed to take possession of valuable antique furniture and a valuable book collection, without going through the proper divorce procedures. It was also designed to place the mother into the position of primary caregiver and to deny the father access to the kids. The audio cassette used in the psychological report that the daughter wanted to commit suicide provided the urgency in the case and formed the foundation on which the protection order was granted. The information supplied to the psychologist to formulate the psychological report was absolutely false. This was later proven in the daughter's own diary entries. The shock and awe effect on the morning of the 6th was planned to alienate the father from the household assets without having a say in the matter and to prove to him that he was up against a formidable enemy and to make him settle the divorce immediately. This did not happen as planned. The father stayed calm and refused to negotiate under pressure, and the lawyer had to provide furniture to the mother and the kids, and no early settlement was reached. The protection order date was early in January. The father and his lawyer was informed at the court that the mother wanted to settle out of court. This would be on condition the father gave in to all her financial demands and accepted the terms of the divorce settlement. This was the second bite at the proverbial cherry to settle the divorce demands quickly. The mother would agree to withdraw the protection order in full. Here the father's access to the kids was effectively utilized to blackmail the father into an early financial settlement. The father once again refused to negotiate under pressure. The protection order and its restrictions on the father denying him access to the kids was a strategy designed to get the divorce settled in double quick time and on the mother's terms. This early settlement pressure was planned for over a year and executed to perfection. They did not, however, expect the tenacity and integrity of the father. The strategy failed. The shock and awe strategy was also designed to prevent the father from utilizing the substance abuse and the state of deep depression of the mother as a defense to acquire principal custody of the kids during the divorce. The protection order was fought tooth and nail by the father, and it ended up being settled out of court on very lenient terms. The mother agreed to these terms as she knew that the 43B interim High Court order would still possess enough teeth to further prevent the father access to the children. She agreed to save on legal costs. So let's talk about the 43B. The protection order starts off with Domestic Violence Act. Let's get it in sequence. And then the protection order at the end of the day leads to a very unfavorable 43B interim arrangement that the court hands down on maintenance, custody, and the interim division of assets in the High Court. So in actual fact, if you have a look from the beginning to right where I am talking now, you've been disenfranchised totally. Now, you are not powerless. The power of one means a lot. In my next video, I will discuss how I've laid charges of misconduct against the lawyer, how I've addressed the psychologist, and how I will address the courts. And you can follow this. The most important thing that I want you to do today, as a favor to me for the first or the second video, is to immediately lay a complaint on the Domestic Violence Act at the Human Rights Commission. Register it register the complaint. If thousands of us do this, we can make them change certain aspects of the Domestic Violence Act to make sure this doesn't happen to others like us. Please like this video, subscribe to my channel. The income I derive from my channel will allow me to do more work like this. There will be videos of where I apply for a protection order where I prove my 40-minute contention. It will show how the courts work. I'm going to expose psychologists in the same manner, and I'm going to definitely expose welfare workers in the same manner. Hang in there. Keep your eye on this channel. We have rights.